your allotted time. We do, as I said earlier, have a number of distinguished panelists, but I think we have to be fairly brutal at this time of the day and say that we must ask that any interventions or comments by panelists be limited strictly to the papers that we've heard in this session, and similarly with regard to any questions that may come generally from the room. Other issues we can discuss over dinner, but I think we have to press on now, as we also have a vote at the end of the comments before we close the proceedings for today. So I would ask if any of the panelists have any comments that they would like to make. Marie Kelly.
Hello. I'd like to just add into the pot another factor that I think you should take into account when you're thinking about the flag state you're going to choose, particularly if there are multiple shareholders, and that's whether you trust the corporate registry and whether you trust the courts of the state. Because I had a case where a corporate registry in a well-known flag state accepted board of directors minutes that were unsigned 18 months after the purported date on them, and then there was a huge dispute trying to go through the courts to get this thing overturned. So just bear in mind, if there are multiple shareholders, that there can be disputes, and you may be up against problems if you're in a state where you don't trust the registry or the courts.
Gianni.
Well, there are a lot of issues, to be honest, I would like to discuss. Well, just one comment, which is very natural when talking about Liberian flag. I must compare with Italian flag, and whilst in Liberia, they are studying implementing the smartphone application in order to help and assist owners far away. Italians have to deal with the consulate in some place very far away from the ship, costing time and money, and with reduced people. But that's another story. It should be a matter of a session, a separate session. We must ask Francesco to arrange next year about the difficulty of Italian flag. One question I have possible to David McInnes about the Charter Party frustration. Supposing that the innocent party is the Charter, and he has the ships withdrawn, wrongly withdrawn by the owner. You say he is entitled to claim damages. Of course, he must mitigate damages. When we are talking about future damages, 2 years, for instance, time charter period, how can be asserted, according to English law, the damage? Because the market is, even these days, is so difficult to foresee. Could be even a good deal for the charter to have been the vessel withdrawn by the owners. So what's the position of English law?
Gianni, of course, you're correct that the owner could be in breach, and indeed that's sort of one side of the coin of what I was talking about, that really focusing on the owner, and the owner has to make a decision if they want to terminate. But if the owner terminates wrongly, then of course they are in breach, and then it is the charterer that claims damages from them. So if you're the owner and you call it wrong, you wipe out your own damages, and then you face a claim by the charterers. I mean, in that situation that you've mentioned, where maybe there's 2 years to go on a time charter, then under English law, you're absolutely correct. There is a duty to mitigate, or rather, mitigation limits the damages you're entitled to recover, and usually the way it would be looked at is that you would just charter in another ship for those 2 years. And if the rate of hire you have to pay is more than under the original charter, then you can sue for the difference between the two of them. That would be the usual measure of damages. There may be more complicated questions if you've subchartered and obviously you lose a fixture and you're sued for damages, or if you have a sub-fixture that is obviously linked to a particular vessel, then your damages may be more than that. But generally it's quite difficult. Definitely the usual measure is just the difference between you go in and charter another vessel with the similar characteristics, and if the market has gone up and you have to pay more, then you get the difference between the two of them. And of course, saying that, when we talk about people terminating, it is the owner that usually will jump too soon when the market has gone up, because they do want to get out of it and charter at a better rate. So that's exactly when charterers may suffer those kind of damages.
May I?
Yannis?
Thank you.
Sorry.
One question for Ernesto Ardía about the safety format declaration which the owner could ask from the ship repairer when starting operation. This seems good, a good solution, which seems like the ISPS code. In the ISPS code, to assure the security of port operation when the ship staying in the port facility, either ship and port facility are compelled to exchange between themselves a DOS, a declaration of security. So it would be really very good if the same could be mandatory for assuring the safety of crew and workers on board for account of the ship repairer. Thank you.
Thank you. It's where I actually, it's a rule where I actually considered when I was drafting my speech, and the reason why is that if the board and the ship repairers exchange as much as information are possible in respect of the areas and of the workers which will be engaged in making the repairs, the possibility of any activity which is too risky shall be indeed limited. This is the reason. And that is the actual rule where I was considering when drafting this idea. Thank you.
I saw two more hands go up, Brian Roberts and Yannis. If we work down the table with Brian first.
Just one comment on Mariella's remark. I happen to be on the side of safety, but whether that is right or wrong, insofar as safety concerns a particular ship and is a matter of fact, would David agree that it is much more likely that a tanker would be at a safe port than a general cargo vessel, because a general cargo vessel would be crawled over with stevedores and the like?
Yes. But I actually err on the side that the abler ports are probably not unsafe anyway. And that's why I urge people to think about when they're asking themselves the question, because if you make the wrong call, the reasons we've discussed, you could be a loser. But I agree with you, but I think at the moment, still on balance, looking at the whole factual matrix, the abler ports are probably safe rather than unsafe, but other people have different views.
And before we have our three questions, a final contribution today from Yannis.
Thanks, Clive. I'm going to take a page out of the book of David, bit large that is, and talk about something that was not on the program to talk about. And I must have been on the phone when you gave us the advice to avoid doing that, because I didn't hear you say it. So I want to go back to what has been a recurring debate about public-private money and this type of thing. And just to say that in the end, I don't think that people really have a problem what type of money it is. They have a problem how it behaves. And the fundamental problem about how it behaves is whether it wants to ignore the basic laws of the economy and the free market. And I think what's happening is there is a distortion in the market that's leading to slightly more oligopolistic practices than what instinctively the smaller owner is used to in a free market. And the worst example of this is the type of zombie companies that are kept alive for much longer periods than they ought to be kept alive, merely because they're really big or merely because they're linked to, other pools of money that are not purely shipping related. And I think that that's the part of it that gets, people upset. There are different rules for different types of money. I think anyone taking a risk should be rewarded if he gets it right and should be penalized if he gets it wrong. You should live by the sword and die by the sword. When you enter situations where if companies order too many ships and they're very big, they can cancel them, whereas if you order too many ships and you're very small, you cannot. Or whether if you're too small and you breach a covenant, the bank comes after you, but if you're too big and the bank doesn't, or it's a bank-related fund that's invested in you, I think this creates distortions. And I think this goes closer to the reason why people are upset with this transitional period of shipping. So, Clive, thank you for not cutting me off on that. Thanks.
We had to have a closing comment on it. I'm sure that there will be lots of discussion that will go on into the evening. But we must, I'm afraid, move on to three questions. You will remember the format from the previous session, where questions will appear, I hope, on the screen behind me, to be read out by Joshua, and I think including the people on the table, if we could all vote on these three questions.
Yes, I think the kind hostesses handed out the leftover remotes. So the first question is, does the law adequately recognize and safeguard the interests of shipping? Yes or no?
And our result? It's a bit like the referendum in Scotland that they had recently. So I imagine there's a sigh of relief, or perhaps the 7% were the lawyers on the table. So actually very close. I rather expected that the vote might have gone the other way. Perhaps earlier in the day, with more people here, it would have been a different result, but nevertheless an interesting one. Second question?
Is private equity something to be welcomed, or is private equity something to be feared?
More votes on this one. Somebody's voted twice. Clearly there is going to be discussion this evening over dinner on this subject.
This is worse than the Scotland referendum.
It's much worse. This would have had David Cameron very worried in England. So the final question.
Who or what should we fear the most? EC regulation, equity funds, judges and arbitrators, criminalization in shipping, or the USCG? We tried to create a bit of controversy in the questions.
And the result on that one? Goodness gracious. Criminalization in shipping. Obviously, it's not a surprise to 29% of people in the room, but it's an issue that we touched on today to some extent. But perhaps it's something that we will find ourselves discussing in more detail next year. Well, that brings the questions to an end, and according to the program, we now have conclusions. Now, looking around, the one person that at the moment I can't see in the room, and who obviously didn't vote on anything, is Francesco Lauro. Are you here, Francesco? Well, I think on that basis, perhaps we should take it upon ourselves in his absence to make a few very brief concluding comments. I think one is, as always, to thank him and congratulate him on putting this together, an interesting program in a fantastic setting, and hopefully followed and concluded by a very good dinner this evening. We always try and finish early or on time if we can. We're in the middle. This isn't the earliest, it's by no means the latest.
They're on time for the bus, but the bus is from somewhere else.
Yes, I think the best thing that we can do is to pack up our bags now, to head to the exit and hope that Francesco is there. Possibly he is the one who's collapsed. But with that, thank you all for staying so late.